Okay, everyone, so I'll get started. Here is the agenda for today. First, I'll just review the video conference procedures, then give a very brief overview of the MEPA process. And at that point, I will open it up to questions, specific questions about the MEPA process only. So again, if you could either use that raised hand symbol or send me a message using the chat box, that would be great. Then after I take any questions that might be about the MEPA process, the proponent will give a project overview, I believe about 20 minutes long, and there'll be photos and plans that they'll be showing on the screen. And then after their presentation, there'll be an opportunity to ask specific questions about the project itself, to sort of clarify maybe something in the presentation or ask them to repeat something. But I would ask that people not comment at that time about their opinions about the project or what the problems may be, but for that period of time, just ask specific questions to better understand the project. After that, we will have an opportunity to for everyone to make a comment. I have received a few requests already, so I'll take those in order. But if you would like to make a comment at that time, again, at that time, please either use that raise hand symbol or send me a text. So again, hopefully everyone's screen looks something like this. Let's see. Let's see. Okay. So hopefully everyone's screen looks something like this. Up here should be the participants, including you. And right here is the raise hand symbol. When you want to ask a question, please use that. Or down in this area is the place where you can send me a message. And I believe the messages will be seen by everyone. I think that's how it's set up. Okay, so the first thing I wanted to just review is the MEPA process. MEPA stands for Massachusetts Environmental Policy Act. It's administered by the Secretary of the Executive Office of Energy and Environmental Affairs. And MEPA is a statute that applies to actions of state agencies and requires them to take all feasible measures to avoid, minimize, or mitigate damage to the environment. And a state agency would be required to do that, whether it's undertaking a project on its own or issuing a permit or providing grant money for a project or making a land transfer, offering an easement, for example. The purpose of MEPA is to ensure that projects disclose their environmental impacts, that alternatives, there's an alternatives analysis to ensure that measures to minimize impacts to the environment are considered, and to ensure that appropriate mitigation measures are identified to be implemented to minimize any impacts that are not avoidable. An important part of MEPA also is this public process. It provides the public a chance to learn about a project prior to state agencies taking any actions. So no state permits or state land transfers or state funding cannot be completed until MEPA is concluded, when MEPA is required. Finally, I just mentioned that MEPA is not a permitting process. However, that's really up to the specific agencies. So if a project concludes a MEPA review, that's not an endorsement. It doesn't mean it can get permitted. It does not affect the ability of the state agency to undertake whatever action it has to take in accordance with its regulations, policies, procedures. Sorry. Okay, so MEPA review is required when there are two factors that are met. The first is that there's a state agency action of some kind. And as I mentioned, it can be a project proposed by a state agency action. There's a state permit involved, funding, or a land transfer. Actions undertaken by the town, permits or issued by a town are not considered state permits. The second criteria is that the project has to meet or exceed a MEPA review threshold that's specified in our regulations. And those range from impacts to land, like land alteration, addition of impervious area, pavement, or in this case, rare species habitat. There are traffic thresholds, wetland thresholds, so a wide variety. But again, MEPA is required when a threshold is met or exceeded, but also when there's some kind of related state agency action. So if, for example, there was a wetlands permit, and that's not the case for this project apparently, if a project needed a wetlands permit but did not exceed a threshold, it would not require a MEPA review. If it required a wetlands permit, for example, and exceeded a transportation-related threshold for maybe the number of parking spaces, the number of vehicle trips it generates, that's would not require a MEPA review because the subject matter of the permit is unrelated to the threshold in that case. So again, MEPA review thresholds are found in our regulations, and they identify not only whether a project is subject to MEPA review, but there are two categories of MEPA review that are the thresholds apply to. By far, most projects subject to MEPA review, 90% or so, require the filing only of an environmental notification form, ENF. However, some projects, generally larger projects, require or mandatorily require or mandated to file both an ENF and then an environmental impact report, typically a draft and final environmental impact report. So some projects are specified in our, based on their level of impacts, are identified as requiring an EIR level of review. However, the Secretary of the Executive Office of Energy and Environmental Affairs has the discretion to require any project to undergo further review in the form of a draft and final EIR, even if it's not subject to that in our regulations. So for this project, the state agency actions are related to the conservation management permit from the Natural Heritage Endangered Species Program, and also a permit from the Housing Appeals Committee. And the review thresholds met or exceeded in this case are alteration of 2 acres or more of rare species habitat that results in a take, and generation of 1,000 or more average daily vehicle trips, and construction of 150 or more parking spaces. So I just say that the comment period will end on May 12th. I'll give you some information on how to submit comments in a moment. And then 10 days later, the MEPA certificate will be issued. And 10 days is a regulatory requirement. That's the time we have to issue the certificate after the comment period ends. So the certificate will review the project and provide analysis of the MEPA office, on its impacts and mitigation measures, summarize comments from state agencies, local agencies, the public, any commenters who submit comments in the comment period. And then there will be a determination as to whether the project has concluded MEPA review or whether further analysis is necessary, in which case the certificate would include a scope identifying additional information and analyses that the proponent would have to provide in a draft environmental impact report. If that were to happen, then there would be, the preparing an EIR is the proponent's responsibility. There's no specific timeline for that to happen. Once it is submitted to the MEPA office, it'll be subject to a public comment period, 30-day public comment period, and then again, there'll be a certificate issued on that draft EIR, and that certificate would identify any analysis that's necessary in the final EIR. There would be a comment period on the final EIR as well. So I guess, under the circumstances, the best way to submit comments is by email. There's my email address. If you choose to send comments in writing, we, for the time being, are getting mail that's on a weekly basis only. So I really urge you, if at all possible, to send comments by email, or if you have any trouble with that, give me a call. My phone number is provided on this slide. So I did want to mention also, before I finish up, that this is not a public hearing. I'm not taking, there are no minutes being taken of the proceedings. I am taking notes of any comments or questions that come up, but the only formal way of getting your concerns or identifying issues into the record is by submitting a written comment, again, by either email or in writing. So that's all I wanted to say. Oh, I'm sorry. I hope. Okay, so are there any questions? I don't see any hands raised, or and I have not received any messages. From anyone. So I'll just unmute everyone for a second and just make sure that no one has a question at this time. Okay. In that case, I will now turn it over to the project proponent. They've provided me with a copy of their slideshow, I guess, or the presentation, which I'll be sharing to everyone. But they will be, speaking to it, obviously. So I will be, let's see, I need to. Okay. Okay, so I think Brian Madden of the project team will be taking us through the slideshow. So Brian, once you speak up, I'll make sure we can hear you.
All right, will do.
Okay, good. So go ahead.
Are you going to pull up the slides?
Oh yeah, sorry. Okay, can you see that now?
Yes, thank you.
Okay, sure.
All right, before I begin, I'll just introduce the project team that are on the call as well. The project proponents for Surfside Crossing LLC, Jamie Feely and Josh Posner. Attorneys Chip Nyland, Paul Haverty, Arthur Reed, civil engineer Don Bracken, and traffic engineer Bob Michaud. And I guess we can go to the next slide. Thanks. So the proposed project is 156 condo unit development proposed under Chapter 40B. This is the site locus. It's 13.56 acres, composed of 4 subject parcels, surrounded by residential development. Directly to the north, there's Sachem's Path that was reviewed by MEPA in 2011. That's 37 units. It's an affordable housing development. There's also Maya Comet Village abutting to the northwest. That's 41 units. That's an affordable housing development. And on the next slide, you'll see that the site is mapped as priority habitat. It was initially listed for a number of rare moths, but following a moth survey approved by Natural Heritage, it was concluded that only 1 moth species was documented essentially on site relating to the habitat conditions. And following a comprehensive review by Natural Heritage, a determination letter was issued on October 19th, 2018, indicating the take of the coastal heathland cutworm. The project proponent is providing mitigation for the take of that rare moth. They're proposing to provide off-site rare species mitigation through land protection up to 20.34 acres through either a conveyance of a property or land and or execution of a conservation restriction with EEA and or providing equivalent funding directed to a qualified conservation entity to support land protection, conservation research, habitat management, or planning projects to benefit the coastal heathland cutworm. During that take determination, there's ongoing litigation, and the contention was that the site should be mapped as priority habitat for the northern long-eared bat. That October 19th, 2018 determination was affirmed by a final decision issued December 5th, 2019, which has since been appealed. Despite the ongoing appeal, the project proponent has voluntarily agreed to implement time of year restrictions, cutting restrictions as it relates to the northern long-eared bat for no cutting in June and July. And so the next series of slides are site photographs, representative site photographs. So that first photograph on the left is looking from South Shore Road into the site. There was a path cut into the property previously to allow for some soil testing that took place. And that second slide is along that path within the central portion of the site. On the next slide is representative habitat conditions, typical pitch pine barren habitat conditions you find on Nantucket. And then the next 2 slides are, next 2 photographs are images looking north and south along South Shore Road. There's a bike path on the opposite side of the roadway. And then the site is on the opposite side. So if you go to the next slide, please. So this is a rendering of the currently proposed project, the 156 condo units across 18 buildings. The proposed buildings will be composed of 2 above grade stories and a garden terrace, with each building containing 8 to 9 units. And then the next series of slides are some renderings that's looking into the site, proposed site entrance. And then the next few are just renderings of the site development, the preferred alternative. There's a proposed community pool, community building, sports court, playground, green space located within the interior of the development. The development is accessed by an internal roadway system with parking spaces proposed off of that. If you go to so this is the grading and drainage plan. Proposed development proposes to connect to municipal sewer and water. Lawn landscaping will be serviced by a private irrigation well on site. There's a proposed pump station near South Shore Road within the southeastern portion of the site. Proposed stormwater management on site has been designed to comply with Massachusetts stormwater management standards. There's a treatment train of deep sup, hooded catch basins, oil grit separators prior to discharge to the subsurface infiltration systems that you see throughout the site. And those are the kind of grid areas. Yes, thanks. And roof runoff from the condo buildings and community building will be discharged into individual on-site subsurface infiltration systems. The proposed site disturbance associated with the project is 12.27 acres, leaving 1.29 acres undisturbed around the perimeter of the site. And if you go to the next slide, Alex, please. So this is a comparison table between different alternatives proposed during the ZBA review process, including the original 156 unit development, which included 60 single family dwellings. 60 single family dwellings and 96 condo units within 6 multifamily buildings. During a lengthy peer review process for traffic, parking, transportation, site design, layout, stormwater drainage, environmental and zoning regulatory compliance, the project proponent submitted a modified plan consisting of 100 units, 40 cottages and 60 condo units within 5 buildings. And then there was a 92 unit alternative submitted with 44 standalone single families, 40 multi-family condo units, and a mix of 8 unit buildings and 8 units located in 4 duplex buildings. On June 13th, 2019, the ZBA issued the comprehensive permit for 60 dwelling units for a total bedroom count of 2,006. And on this table, you'll see just the breakouts of the different plans that were proposed, submitted by the project proponent for new land altered, impervious acres, vehicle trips per day, number of parking spaces, number of bedroom counts, which is primarily the driving factor for water use and wastewater generation in the next 2 numbers. And then finally, you have the undisturbed land on site. And I guess at this point, I'll turn it over to Bob Michaud, the traffic engineer, to review the transportation items of the project.
Thank you. Can everyone hear me? Can everyone hear me?
Yes.
Yeah.
Yes.
Yeah, we can hear you. Sorry, Bob.
Okay, I'm getting feedback. Okay, are we good to go, Alex?
Yeah.
Okay, so I'll give a brief overview of the history of what we've studied here for the property. It's been subject to an extensive peer review process, an independent study that was conducted for the town of Nantucket by Beta Group, and subsequent consultation among the parties that include MDM, the peer review consultant Tetra Tech, the Beta Group, and the planning department in terms of determination and agreement, if you will, concurrence of project impact in and around the site. So the site on the next slide, of course, is proximate to the South Shore and Surfside intersection. It's the principally impacted location on the diagram. It's shown as the red circle. Through the prior iterations of study, both by the town of Nantucket via the Beta Group study and peer review comments issued by Tetra Tech, a number of additional locations were considered to determine their applicability to the project based on its impacts. You'll see a series of orange circles that would indicate approximately 6 additional locations beyond the primary impacted location that were considered in prior studies, as well as in the production of the most recent traffic impact and access study, which is dated to April of this year. The next slide will give a snapshot of where the original project was proposed at 156 units. That original project was documented as part of a traffic impact and access study that MDM prepared first in February of 2018 and amended and updated to July of 2018. The July 2018 study was the basis of peer review and also was done at about the same time that the Beta independent traffic study was done for the town of Nantucket. Under that original project, approximately 1,272 daily trips were estimated to be generated, and between 88 and 113 total peak hour trips would have been generated. Under the current preferred program at 156 units, we're below those numbers by about 20% during the peak hours and about 10% reduction on a daily basis. So under the current preferred plan, we are generating a peak directional trip impact of just under 60 trips per hour and a two-way overall traffic impact of between 72 trips in the morning peak hours and 87 trips during the evening peak hours. I will point out that in both the original study and the current preferred alternative, that none of these trips have been adjusted downward to reflect the alternative travel modes that are available to serve this particular property, that include bus service by the Nantucket RTA, which maintains a stop at the very nearby intersection of Surfside and South Shore Road, and the fact that the site is immediately proximate to the South Shore bike path, which connects as well to the bike paths that converge at that same intersection very close to where the property is. So these are unadjusted ITE-based vehicle trips. The next slide indicates, relative to the area roadway infrastructure, how those peak hour trips would be generated. If you want to go back a couple of slides, Alex. One more. Yeah. Okay, one more down. And one more. These are arrows, if you will, that would indicate over the course of a peak hour, a single hour, in this case during the morning peak hour, how many additional vehicle trips would be generated along Surfside Road, Hopper, which is the middle arrow on the upper side, and Fairgrounds Road, as well as to the lower portion of Surfside Road to the lower right. And you'll see that in no case does the project generate any more than about one new vehicle every 2 minutes on any particular roadway beyond the principally impacted intersection of Surfside and South Shore Road. And likewise, in the subsequent slide, the next slide, the evening peak hour numbers are highly consistent with that same pattern and that same trend. When we look at the intersections beyond the primary impacted location, which is shown in this graphic as the red dot again, you'll see that the relative trip increases for the current preferred alternative fall below 3% of the ambient traffic volumes at any other location that's been studied either by Beta Group as part of their independent study for the town, or that has been subject to peer review. The nearest impacted location would be My Comet Road, just to the north of the Surfside, Fairgrounds, and South Shore Road intersection. The relative trip impacts from this project would be about 2.5%. And as we proceed north towards Sparks Ave or Old South Road, those same trip increases represent less than a 2%, and in many cases less than a 1% change in overall volume. So immaterial impact beyond the principally impacted location. From the perspective of traditional traffic impact standards and standards that are well recognized by the Massachusetts Department of Transportation, locations that sustain less than a 5% level of traffic impact do not warrant detailed study or evaluation. That finding was concurred by Tetra Tech in their peer review in 2018. The next slide, Alex, would indicate the parking characteristics of the project. We turn to the industry standard rates that are published by the Institute of Transportation Engineers, ITE, and we apply those standards to the bedroom count that is currently proposed, which is 283 bedrooms. On an average peak demand basis, the site would generate a peak parking demand of about 187 vehicles. Statistically, of all surveyed sites that comprise the database that lead to these rates, the 95th percentile confidence level, if you will, in other words, the level at which you would most of the time see a demand at or below, is under 200 vehicles parked at this site. There will be occasions when there are peak parking activities during, say, seasonal events, summertime, for instance, and the ITE publishes what's known as 85th percentile parking demand characteristics, which if applied to the 283 bedrooms would generate a peak overall demand of 244 parked vehicles, inclusive of all visitor-related activity. We know that the zoning bylaw for Nantucket, if it were applied here based on its zoning provisions in other areas of the island, would result in a 1.0 per bedroom parking rate, or 283 parking spaces. The zoning board, the ZBA decision on Surfside Crossing actually had made a provision for additional parking for the recreational building on the site at 8 additional spaces. If added to the 1 space per bedroom ratio, would result in a total parking supply requirement of 291 parking spaces. And what's being provided is 299. So the conclusion here is that on an industry standard basis, we have more than ample parking to support the use, and we're also consistent with the provisions of the Nantucket zoning bylaw on a per bedroom unit, as well as the ZBA decision on adding additional spaces for the recreational building. And that supports why the parking supply is being provided at that number. So in conclusion, the parking impacts from this particular project are modest. They're confined really to the nearest intersection at Surfside Road and South Shore Road. The project in its prior iterations of higher impact indicated that there was concurrence by peer review and the town's consultant Beta that the principal impacts of this project would be contained to that location, as well as one additional location, which is the Maya Comet Road intersection just to the north of this particular site. In the prior process that the applicant has undertaken, there is concurrence that those are the only two materially affected intersections, neither one of which is subject to Mass DOT jurisdiction. They're all local jurisdiction roadways. And the submitted material to MEPA has documentation of that concurrence and the protocols in which any potential mitigation might be applied to off-site locations being limited to those two locations. That concludes the traffic presentation.
Thanks. Is there anyone else from the project team who is going to present anything?
No, we'll be available for any questions that come up, though.
Okay. All right. Are there any questions about, so again, specific questions about the project, questions on the presentation? Please let me know. Haven't received any indications yet. Yeah, I haven't received any indication that anyone has a question. So in that case, we'll go on to the some public comments. Excuse me while I get my list of people who've wanted to comment. I think the, oh, okay. So there was one question, I guess for Bob. The question is, what percentage of impermeable surface is generated by 299 parking spaces?
It's actually a question that might be best answered by Don Bracken.
Okay.
Can you hear me now?
Yeah.
We did not break out specifically the areas for the parking spaces. We did an overall paved roads, parking and sidewalks area on the site plan. It indicated 162,028 square feet for those areas. We would have to run calculations to break out just the parking spaces.
Okay. Another question, are there any questions, are there any other amount of residential spaces of this kind provided anywhere else in Nantucket? So I guess maybe is sort of the ratio of parking spaces for units or bedrooms, comparable to any other residential developments on Nantucket? Residential only, not commercial or public parking.
This is Don Bracken again. I can say from my experience, as previously mentioned, the bylaw requires one space per bedroom. And as far as I know, that has been the standard for this type of development.
Okay. So I don't see any other questions. So let's see. I did get a question from, I did want to ask a question just about the wastewater issues. So is there sufficient capacity at the treatment plant to accommodate the flow from the project?
Yes, there is. We've had several meetings with the sewer department. And we also, our office has submitted many sewer extension applications up until recently. The plant is not at capacity. It has the capacity for the proposed flow.
Okay. And who will own and operate the pump station?
Based on our meetings with the sewer department, they would like to own and operate the pump station.
Okay. Okay. Let's see. All right, that's all I have for now. So let's see. I think I maybe just received another. Okay. All right. So I think the first person we'll take comments from is Mr. Witten, representing the Select Board in Nantucket. John, can you unmute yourself?
Yes, good morning. Good morning, Alex. Can you hear me?
Yes.
Great, thank you. Good
Go ahead.
morning. And good morning, everyone on the call. My name is John Witten, and I'm the attorney with KP Law in Boston on behalf of the Nantucket Select Board. I speak on behalf of the Select Board as Town Council. And Mr. Struitsky, I wish to address 3 issues relating to the applicant's submission to MEPA, and their submission date is dated March 6, 2020. My comments will be brief, as the Select Board will be submitting a detailed letter fully addressing why this matter must be required to submit an environmental impact report pursuant to relevant regulations. First, as I've mentioned in my email correspondence, and as the applicant is well aware, the applicant has intentionally ignored the unambiguous requirement of 301 CMR 11.05 subsection 2 governing the filing of an ENF. There can be no dispute that 301 CMR 11.05 subsection 2 requires the filing of an ENF within 10 days of the filing of the applicant's appeal, are optional nor waivable. It is a regulatory requirement and has the force of law. Respectfully and with emphasis, MEPA has no authority to waive the provisions of 301 CMR 11.052. Violating the unambiguous requirements of the regulation was the applicant's choice. The applicant should suffer the consequences of its intentional neglect, and MEPA should reject the application outright or simply require an EIR. Second, as we will discuss in detail in the forthcoming letter from the Select Board, the proposed project's impacts due to traffic generation, wastewater disposal, stormwater runoff, impacts to endangered species habitat, all cry out for an EIR, as does the project's gross inconsistency with literally hundreds of years of land use planning efforts on the island, and the project's inadequate, illogical, and absurd site design all support the demand for an EIR. Most notably, MEPA must require an EIR due to the project's total avoidance of any alternatives analysis. The ENF's alternatives analysis lacks any discussion, let alone any analysis of a no-build alternative. There cannot be an honest preparation of an alternatives analysis if one of the alternatives is not a no-build option. An alternatives analysis that includes only those options attractive to the developer is grossly inconsistent to a well-established process dating back to the inception of MEPA and at the national level, NEPA. Neither statutory program could function if every developer ignored the responsibility of providing reviewing agencies with an analysis of what if the project did not get built. Most developers paint the no-build option as grossly problematic or financially crippling. This developer has taken a more brazen approach by simply omitting the no-build option altogether. An EIR must be required to provide MEPA and other reviewing state agencies with an honest alternatives analysis. Without one, and reliant on the applicant's half-baked E&F, makes a mockery of the MEPA process. Third, by holding the site visit remotely through no fault of anyone's, MEPA is deprived of the very benefit for which site visits are held, that is, to visit the site. No amount of aerial photographs, site plans, GIS manipulation can substitute for MEPA's physical review of the 24 roadway intersections that the proposed project will denigrate, or the endangered species habitat that this project will irreparably destroy, or the stormwater impact the proposed project will have on the island's sole source aquifer. MEPA holds site visits for a reason, to help inform the analyst, here Mr. Stritsky, as to the real world conditions that the project will impact. That simply cannot be done remotely. There is no good or rational reason why this process cannot be continued until a safe point in time, whether it's June or July or August, so that the purposes of the site visit can be fulfilled. This project is not going anywhere soon. The applicant has recklessly applied to the Housing Appeals Committee to modify the project, and the Board of Appeals has authorized me to oppose that modification, which, if successful, will remand this matter back to the island. A delay of 2 or even 4 months will have no effect on this project's future. Mr. Stritsky, as the Select Board's detailed letter will make clear, the project cries out from the 4 corners of the Commonwealth for an EIR. And respectfully, if MEPA does not believe that this project requires an EIR, then it is impossible to think of a project that could. Thank you, Mr. Stritsky.
Thanks, John. So let's see. The next person was Paul Durensis. Paul, are you on? Can you unmute yourself?
All right, I'd like to defer my time to Bruce Perry, if that's possible.
Sure. Okay. Mr. Perry?
Does that unmute me?
Yes, I hear you.
Okay. Okay, so Bruce Perry, I'm on a butter from 14 South Shore Road, which is across the street. And I'd just like to say, as Mr. Whitner said, that we're here to determine whether or not the information submitted is sufficient to provide a complete review of the project. So I did submit a letter to the department on April 7th or so. And so I just want to make sure that's in the record that it got there. So the first comment I'd like to make has to do with the solid waste and hazardous waste generation of the project. In the E&F, the applicant said there was going to be no solid or hazardous waste generated by this project. And as my comments in writing said, that it's hard to believe that they're going to strip 12 acres of land and build 18 condos and driveways and roads and not have any generation of solid or hazardous waste. And so those questions need to be answered in the EIR. In the consistency section, it talks about the adequacy of town infrastructure. And the response from the applicant was that municipal sewer and water. As I said in my comments, there the sewer from the Weston and Sampson comment back in January to the ZBA did not recommend that this project connect to the force main. The applicants decided to ignore that in filing this ENF. In addition, there was some concern from Weston and Sampson about construction over the existing sewer lines that are across the property from north to south, and the proximity of heavy machinery driving over those sewer lines and how they were going to mitigate any impacts. That was not discussed in the ENF. And the town wastewater director commented that if the sewer line were to break during construction or any time thereafter, he thought there would be probably 30 to 40,000 gallons of raw sewage spilt on the property before they could shut the lines down. Water supply. In my comments, I submitted some documentation about the fact that town is operating under a expired water withdrawal permit from DEP. It expired in 2015. It has not been renewed or expanded. The town has applied for a new license and is still awaiting a permit from DEP. So to add additional capacity to already expired permit would be requiring the town to do something that is illegal, and therefore shouldn't have to do it. There's also concerns from the fire chief during the ZBA hearings, the adequacy of the water supply if there was an emergency on this project, and if there was an emergency on anywhere else in the water line, including the town schools, and that issue was not addressed in the ENF. More inconsistency, the applicant in section, I think it's 3B4, it talks about compatibility with adjacent land uses. The response from the applicant doesn't answer the question. So they need to answer the question. Please look up what the response was, just a second. Yes. So the response from the applicant, the site is mapped LUG2 residential. The development serves to further enhance the ability of the Nantucket residents to live and work on the island. That is non-responsive to the question. And whether or not this project enhances the ability of residents to live and work on the island is open to discussion, and none of which was contained in the ENF. In section D of the same consistency, it talks about the adequacy of the infrastructure. Again, as I mentioned before, sewer and water seems to be lacking. And then it also, in D3, talks about open space impacts, with the applicant saying that NA as being not applicable. And it's hard for me to believe that the town would think that the clear cutting of 12 acres of priority habitat would not apply to its open space impacts. Rare species. To this day, the applicant has refused access for third parties to do any sort of searching for rare species on the property. The bats are one issue, but the other issue is a formal rare plant search. There has been some representation by the applicant that they will look for a plant that's known there when it's in flower. It's the New England blazing star. I know that there are other rare plants on the property, and I have to say that I found them about 10 years ago when I was doing some work for Sation's Path, and we were looking for rare plants. And so I know they're there. They weren't looked for, so further searches have to be done. Other on-site issues are lighting and its impact on the environment, noise generation for all these, what look like outside heating and cooling systems close to property lines. And that's about it. Thanks.
Thanks, Bruce. And we did receive your comment letter, so thank you.
Alex, can I add something to what Bruce said?
Sure, is this,
Paul Lorenzus.
okay, sure.
I was present at most of the Board of Appeals hearings. At one of those hearings, I asked the Board of Appeals to ask the developer to provide access to the property. The answer came from the lawyer for the developer, and the answer was a loud no, which is in the record. I want to underscore that with a project proponent denying access to the property, how very important the site visit requirements are. And I would remind you, Alex, of the provisions in the regulations that specifically say that the project proponent is supposed to, the words are, the proponent shall be required to provide accompanied public access to the project site during the site visit. This is 1106-2. Unless such access is infeasible for public safety reasons. Now we understand the current epidemic, but that will not last forever. So I want to underscore the prior comments that where a proponent has denied access and where access will be feasible in the future, the proponent shall be required to provide accompanied public access. And we'd like to see that happen here. The other point I would add to Bruce Perry's excellent presentation is that I sat through many, many hearings at the Board of Appeals, and there was an extensive record created with experts on all sides saying all kinds of things on all relevant subjects, a very extensive record. This ENF does not provide that record to the MEPA office. Instead, what the applicant has done is picked the most favorable thing they can think of as their position from their experts, disregarding pretty much everything else that was introduced. As I listened to all of those hearings and all of those sessions, and I compare it to the ENF, the conclusion I reach is that the ENF does not fairly, accurately, or completely present anything close to the environmental record that's already been developed for this project. And therefore, I would say the application is incomplete because all of this material is available. All of this material could have been attached to the ENF. It wasn't. And I draw your attention to the regulations that say specifically that the secretary may reject an incomplete ENF, in which case the secretary shall notify the proponent, who shall file and circulate a new ENF and publish a new public notice. This is 301 CMR 051. What you have in front of you, I would estimate to be less than 10% of what's available and part of the record. That completes my add-on to Bruce Perry's comments.
Thank you, Paul. So next person,
Alex, this is Paul Haverty. I just wanted to jump in here real quickly to let you know that Attorney Nyland was unable to access the meeting via his computer, so he's participating by phone. I'm not sure if you got my chat message telling you that.
yeah.
So I just want to ask if you could unmute his phone, because he's got no way to do it, I think, on his phone.
Well, there were a couple other people who had signed up. Would it be okay if we just took a couple more commenters?
No, that's fine. I just wanted you to unmute his phone so that he can speak when he is prepared to speak. I'm not asking.
Absolutely.
No.
Yep. Okay, thanks.
So his number is, I don't know if you got the chat message I sent.
Yeah, I
But
do.
he's participating under 617-930-8500.
Okay.
Thank
So
you.
I think there are two more commenters, and then I'll unmute Chip.
Great, thank you.
Okay, thanks. So the next commenter is Emily Molden. If you could unmute yourself, Emily.
Sure. Can you hear me okay?
Yeah.
Great. Thank you very much, Alex, and good morning to everyone. I am the Executive Director of the Nantucket Land Council, and I submitted a comment letter to you yesterday morning, which details the Nantucket Land Council's major concerns with the ENF filing and with the project in general. And in it, we also request an environmental impact report be required. As you may or may not be aware, the Land Council is an environmental nonprofit organization that's been around since the mid-70s. And the focus of our work and our experience, among other things, includes the protection of rare and endangered species on Nantucket and their habitat, as well as the protection of the island's water resources. We've also worked quite closely with the state throughout the years, holding multiple conservation restrictions on island that were required as habitat mitigation for development projects. In fact, adjacent to this property, the Sachem's Path 40B project that we've already heard about is one property on which we hold such a CR that was mandated as part of their MEPA comprehensive management permit. I'm not going to go through all of the elements of my letter, but I did want to highlight and emphasize a few points. And following the MEPA process, recognizing that the state's natural heritage program will be proceeding with the comprehensive management permit, I really want to start by emphasizing the value and importance of this particular site as it relates to habitat in the surrounding area. Thanks for posting that aerial up there. As you can see from this aerial map that I provided with a comment letter showing the project vicinity, this 13.5 acre parcel really is an integral part of an existing corridor of natural habitat that links up protected areas located to the south and the west through the high density, highly developed mid-island area up to thousands of additional acres of open space beyond to the north and the east of here. And as we know, this type of connectivity is really vital for providing ecological corridors, for enhancing species resilience to development, and promoting the movement of species throughout the landscape in general. This connectivity is also why we are really hoping the state will require on-site mitigation for impacts to rare and endangered species. As pointed out, one of the MEPA thresholds that mandated this particular filing is for the clearing of more than 2 acres of state-listed species habitat. And while the site is officially mapped as priority habitat for multiple Lepidoptera species, and one of these was documented on site during the specific Lepidoptera survey conducted by the proponents, as discussed by Brian earlier, there's also a great deal of evidence that's been provided as testimony from the town's experts and our own experts that include island botanists and wildlife biologists, as well as our basic knowledge of the surrounding properties, including the Sachem's Path site, that this property is also likely to contain the habitat for other rare and endangered species, including, as you heard, the state-listed plant species of special concern, New England blazing star, as well as possibly Sandplain blue-eyed grass, and also the federally threatened and state endangered northern long-eared bat. The habitat that's found across this site consists primarily of pitch pine and scrub oak forest with some pockets of coastal shrubland and heathland. And while the northern long-eared bat research is still relatively new on Nantucket, it has definitely demonstrated the importance of precisely this type of pitch pine forest for the species. The fact that Nantucket lacks the typical eastern hardwood forests where you often find the species on the mainland makes this habitat likely a limiting factor for them out here on the island. The island research that has been conducted has detected a number of maternity and other roost sites, and outside of a number of structures, these roost sites have all been found in the bark of pitch pine trees. The bats are insect feeders, so the combination of these pitch pine trees with the complex understory that we find here really make it the perfect feeding and roosting grounds for this species of bat. And an expert that was hired by the town also documented significant northern long-eared bat activity adjacent to the property with acoustic detectors. And all of the other acoustic surveys that have been conducted around the island really show the greatest activity consistently occurs within or directly adjacent to these pitch pine scrub oak stands. The Land Council, as well as the town, have petitioned the developers on multiple occasions since the beginning of this project proposal to allow experts on site to survey for these other important state-listed species, and permission has never been granted. But now is the time before the site is cleared to determine whether these species are present so that the impacts of the development can be properly assessed. The state does have the opportunity at this stage in the process per the MEPA regulations to request these surveys and to confirm whether additional priority habitat in fact exists here. So we are requesting before the conclusion of the MEPA process that the developers are required to allow these surveys to take place before proceeding with additional permitting. It is certainly unfortunate that we can't all be out on the site today, especially given the fact that it's the first time we've seen sunshine in a while, but it certainly can still be arranged to have scientists on site to conduct these surveys. The state's policy, as we heard in the initial presentation, is first to avoid impacts to rare and endangered species before minimizing and mitigation. But how can the state work with the developers to avoid or minimize impacts on this site if we don't know whether or not these species are there? The Land Council is also very concerned about the lack of open space and habitat protection built into this project in general. As I outlined further in our letter, the project is surrounded by a number of sensitive water resources, including Nantucket's Wellhead Protection District, a number of down gradient private drinking wells, and also an impaired water body, Myacomet Pond, which you can see here on the screen, which is classified as one of the island's great ponds. The amount of impervious surface that's proposed for this site, which is another MEPA threshold that mandated this filing, as well as the large area of landscaped land, definitely threaten these water resources. Additional open space and natural habitat protection should be required, which would be coincident with on-site rare and endangered species mitigation. And we also would request additional information on proposed stormwater infrastructure and hope that this would include more than just the subsurface units proposed, but also as much pretreatment and bioremediation best management practices as is possible. I think I will leave my comments at that for today, and certainly thank you for the time and opportunity to speak.
Thank you, Emily. So the next speaker is who requested a chance to talk is Gretchen Callahan. Can you unmute yourself? I don't see Gretchen listed on the participants. I don't know if she's calling in. Well, why don't we take the next person, and if Gretchen, you are still here and can send me a text or something, then you can go after the next person, who is Chip Nyland, one of the attorneys for the proponent. And let me just find. Okay, Chip, I think I've unmuted you.
You did. Thank you, Alex. You know, I'm a dinosaur, so I'm not sure how I could get into Zoom meetings, but wasn't able to get into this one. So my apologies. But you know, thank you for the opportunity. As you may know, I'm environmental counsel. I came on fairly late in the process when the issue of the northern long-eared bat arose, and the town and the Nantucket Land Council appealed the decision of Natural Heritage that the property was not priority habitat for the NLEB. So I haven't been at the CBA meetings, but I've been involved in this matter and in the ENF. So I'd just like to respond to a couple of items that have been raised by Attorney Whitten and others. So first, with respect to the timing of the filing of the ENF, this certainly is not anything that has been a surprise or hasn't been discussed for a long time. The purpose in 11.05 for having a timely filing is to make sure that the ENF is filed well in advance of the commencement of the project. It allows the opportunity for people to look at alternatives and for state agencies to be able to have a record to make a decision. In this instance, there's been, in terms of the two permits that you referenced at the beginning of this discussion, the HAC appeal has been filed, but as Attorney Whitten has conceded, admitted, and discussed with MEPA, it's certainly more than a year away from having any resolution by HAC. There haven't been any trial proceedings. The only thing that's taken place have been, briefings. So there haven't been any of the issues that have arisen today have not been tried or presented. Experts haven't been put on the dais and subject to examination, and experts have not offered any opinions. So we're well way away from that decision being made, consistent with the intent of MEPA. Secondly, with respect to the natural heritage issue, with respect to rare or endangered or threatened species on the property, I think you're aware, and I certainly have made Mr. Whitten and others aware, that I met with the former chief of MEPA, Deirdre Buckley, and indicated that we couldn't file the ENF until we had a resolution of this northern long-eared bat, which, as I indicated, as people know, was appealed by the Select Board and the Nantucket Land Council to Natural Heritage, because the ultimate disposition of that case could have an impact on the ultimate design of the project. So what we indicated was that following the litigation at the administrative level, that we would file the ENF. That was communicated to Mass Housing, to the Housing Appeals Committee. Paul Haverty, who's counsel for Surfside, is on this call and can confirm that. And a decision was made by the administrative law judge and by the commissioner that the Select Board and the Nantucket Land Council did not meet the regulatory requirement to show that that site was priority habitat for the northern long-eared bat. And that was decided in December and was then appealed to Superior Court. We indicated that we would file after that, and that's why we filed the ENF in March. And in terms of any permits, we do, as I think Emily and others have referenced, and Brian certainly did at the beginning, we need to file for a management permit, comprehensive management permit from Natural Heritage for the work that is being performed on site, and we haven't filed that permit yet. So as far as we're concerned, this MEPA filing is more than timely. It's early enough in the process for all agencies to have the opportunity to view the project and its alternatives. I think it's also interesting that in terms of what's taking place out here, as Attorney Dorenz has mentioned, this isn't a typical situation where, you know, MEPA is the first stop in the permitting process. As he indicated, this has been in front of the ZBA and local boards for almost 2 years. He indicates that there's an extensive administrative and environmental record out there. Most of the items that are in front of you have been discussed ad nauseum in front of local boards. There have been at least 5 or 6 peer reviews that have taken place on behalf of the town boards. So this isn't a question of MEPA being the first stop for the public or for agencies to get information on alternatives. Most of that information is available. And I think Paul makes a good point, and perhaps it might be worthwhile to supplement the ENF with some of these peer reviews, and I'm sure that the town, the select board and the town and others will take the opportunity to offer whatever they think is relevant. But I think the most important thing is that that information is out there, Alex, and for MEPA's purposes, you know, it has been evaluated. I think the other point I want to make with respect to natural heritage is, and then I can turn it over to Paul Haverty or anybody else that may want to speak. This site is determined to be priority habitat for certain species, but it was not determined to be priority habitat for the northern long-eared bat. When that takes place, there are specific regulatory provisions that govern how one seeks to add a certain species or a certain property as priority habitat for that species. The Select Board and the Nantucket Land Council attempted to do that. They thought they followed the process, and it was determined that they did not follow the process. That was in litigation. It's not something that's subject to MEPA. They have filed that in an appeal of that determination by the commissioner that they failed to meet the requirements of the regulations, and that's where that is to be determined. I assume that Natural Heritage will issue a comment letter during this MEPA process, and I think they'll echo that sentiment that this is a legal matter and that there's sufficient information with respect to what's taking place on that property. And the final point I would like to make is with respect to the issue of the existence of northern long-eared bat, the proponent agreed a long time ago, early in the process in front of Natural Heritage, that they would not cut any of the trees that could be habitat for the NLEB during the time that the federal government and others under the 4D rule don't want any cutting, which is sometime during the summer. So we agreed that we weren't going to do that right from the beginning. So I think I've taken up enough of your time. I want to thank you for convening this. These are trying times. I think whether or not you're going to have a site visit on your own to see the site, that's up to you. But certainly, there's no requirement the site visits have to be open to the public. They're over the lengthy time of MEPA, I know that site visits aren't held all of the time.
Thank you. Was there anyone else from the project team who wanted to add to that?
Alex, this is Paul Haverty. I just wanted to fill you in on the status of the appeal process in front of the Housing Appeals Committee. So the appeal was filed last July. Shortly after the appeal was filed, 2 different parties moved to intervene into the proceedings before the Housing Appeals Committee. Both of those motions, which were opposed by the applicant, are still pending. The HAC has not ruled on either motion. Subsequent to the initial conference of council, the Board of Appeals filed a motion to dismiss, claiming that the applicant had not complied with the Housing Appeals Committee requirement to submit with MEPA within 10 days of filing of the appeal. We have opposed that motion, and the Housing Appeals Committee has not yet ruled on that motion. The 10-day requirement is in fact a Housing Appeals Committee requirement. It's not a MEPA requirement. There's nothing within 301 CMR 11.052 that requires a filing within 10 days of any process. So obviously that's an issue for the Housing Appeals Committee to resolve. It has nothing to do with the MEPA process. The Housing Appeals Committee process really hasn't begun. Nothing has occurred beyond the filing of those motions to intervene, and then the subsequent filing by the applicants of a request for a modification to do the project consistent with what has been submitted to MEPA, which all along was the reason for delaying the MEPA submission to the HAC, simply because the applicant wanted to make sure that it was also going to be filing its request for modification for the project which it intends to move forward on. And also, of course, as Chip had noted, we had to wait and see what the result of the natural heritage appeal was. That was another reason for the delay, because we didn't know exactly what the circumstances would be when we actually finally did file with MEPA. So there's still a significant amount of time left in the Housing Appeals Committee process. I think it would be irrationally optimistic to think that this is something that's going to be completed in less than 2 years, given the amount of time it's taking the Housing Appeals Committee to rule on things, including motions, that have still been pending for closing in 8 or 9 months now. So I just wanted to make sure that you were aware that we were still really in the very early phases of the Housing Appeals Committee process, and there's no decision imminent anytime soon. That's all I have.
Okay, thanks. So I just got a request from Bruce Perry to make a comment. Bruce, go ahead. And then there are 2 other people after Bruce who've signed up so far. So go ahead, Bruce.
Okay, back on. So I've got 2 comments about the fact they did not file within the 10 days. The regulations do not give them the right, or they do not have the authority to waive those regulations. If the regulations does say shall file, it means that they shall file. If they don't, then they're in violation of those regulations. A second separate comment on whether or not the applicant wants to supplement the ENF. It's up to the applicant to provide sufficient information to the department when it files the ENF. And then if it needs to submit additional information, it should be required in an EIR so that the process continues and everybody has the ability to review it in a timely manner and comment on it. To supplement an ENF with the number of questions that are still open on this project, I think is inappropriate. And that's my comments.
Sorry, Don, is next you want to add something about water and sewer issues?
Yes, I just wanted to address a few points that were made. First, I just wanted to refer to the Bristol Engineering Advisors hydrogeological assessment from September 2018 that was requested by the Board of Selectmen. Page 4, it indicates in the report that the Wanacommet Water Company has sufficient supply and storage capacity to meet the additional demand of the Surfside Commons project that they will require. I think there were questions about whether or not we had adequate supply. I think that should answer it. As far as the sewer questions are concerned, we have teamed up with Stantec Consulting Engineers who specialize in water and sewer systems, and they have been involved in working with starting to try to at least work with the sewer department to come up with the best connection possible. They will also be providing construction details on the protection of the existing sewer lines that go through the site. The other comment that was raised was the fire department concerns. We have met with the fire department and have had correspondence with the fire department already regarding these current plans. In fact, we got a letter back from them today asking us some questions and to provide additional information, which we plan on doing within the next few days. So we feel confident that with this new plan that we can meet the fire department's requirements. And that's it.
Okay, thanks. So John Whitten, another chance to talk?
Yes, thank you, Alex. I'm just going to repeat what I said earlier in response to both Attorney Haverty and Attorney Nyland's comment, as well as Mr. Perry picked up on it as well. This no discretion piece is important, and it can't be overstated. My brothers seem to suggest that there's no harm, no foul here, but one could imagine if the shoe were on the other foot, if the municipality had missed a deadline, what the outrageous response would be from opposing counsel. That there's no flexibility here. And Alex, we would urge MEPA to take this matter very seriously. It's a slippery slope. The regulations that I've cited, the regulations that will be cited in the letter, do not provide MEPA any flexibility or relaxation. Attorney Haverty seems to intentionally or unintentionally move the cups around. We're not talking about the Housing Appeals Committee. We're talking about MEPA. And the regulation that governs the Housing Appeals Committee in terms of a 10-day filing with MEPA is the same regulation that applies to MEPA. So this is correct. MEPA does not have jurisdiction over the Housing Appeals Committee. We have raised that issue there, and we expect a favorable ruling there. But here, we're talking about MEPA's obligation to enforce its own regulations. So once again, we would urge MEPA to reject this application as not timely filed or simply require an EIR, and we will waive any claim that it is untimely filed, provided that MEPA requires an EIR. Thank you.
Thanks, John. Emily Molden, you want to add something?
Yes, thank you, Alex. Just based on some of the previous comments, I just wanted to emphasize again the fact that while much of this has been discussed previously and peer reviews have been provided on many of these issues, no one has been allowed to access the site to actually evaluate impacts. And also, again, just to emphasize that the MESA regulations do specifically allow the state during the MEPA process now to request additional on-site surveys to determine if additional priority habitat not previously mapped is present. And this is something that would further inform the conservation management permit and any required mitigation for impacts of the project. Thank you.
Thanks, Emily. So I see that someone participating via Paul's iPad has their hand raised. That Paul Haverty, I don't know if that was you, or if there's some other Paul who wants a chance to make a comment.
Alex,
That's Paul Durensis.
Oh, Paul. Okay, great. Thank you.
I just want to answer the question, not the question, the statement from Bristol Engineering, quoting a September report. This is Paul Durensis. I'm counsel for Nantucket Tipping Point. And the actual quote, if I could read it, is not what was stated by the developer's engineer. It says, quote, increasing demand from this project and others means that the water company will be required to either implement water conservation policies or seek a permit for additional withdrawal volume in the near future. That's the actual state of affairs with regard to the water situation. Thank you.
Thanks for that, Paul. I appreciate that. So it's we have about 20 more minutes. I think I literally have to end at 12, but if do have time if anyone else wants to make any more comments. Okay, well, not hearing from anyone. I appreciate everyone participating. I'm sorry for didn't necessarily go as smoothly as I hope, but hopefully everyone got a chance to learn more about the project and hear some of the comments. I do appreciate everyone participating this way. So again, I urge you all to send in comments, preferably by email by the 12th. And in particular, the comments that are helpful to us are many of which have been already stated are sort of impacts that were not adequately, in your opinion, disclosed in the ENF. Additional, based on your knowledge of the area, other environmental effects that the project could have, and also any comments you have on appropriate mitigation measures. So those are things that are very helpful to us in evaluating the project and how it measures up to the MEPA sort of review standards of identifying impacts and minimizing impacts, those impacts and mitigating when necessary. So thank you all for participating. Feel free to send me an email or give me a call if you have any questions after today. Okay, goodbye.